We're saying about the role of the IT lawyer these days, that there is certainly, in terms of the types of advice being asked for, particularly on the vendor side, a lot of academic advice in relation to how is this thing going to play out if we present technology or services like this. I think where it's coming from is potentially that the take-up in cloud amongst SMEs, large corporates, banks and finance houses hasn't been what it might have been over the last 4 or 5 years. I think that's generally acknowledged in the industry. And there are reasons for that, and law and regulation have a lot to do with that, but there are other things as well, because maybe perhaps the nascent nature of the technology, the lack of harmonisation, as Ian alluded to a couple of times, and the lack of I suppose transparency in relation to how these services really operate, where the data is located, etc. We at Matheson act for quite a number of vendors, cloud vendors, one of whom Ian alluded to a moment ago, who's an enterprise licensed software provider essentially, and needs now to look at its cloud models very much more seriously than it has been. Coincidentally, it might work to its advantage because of certain case law, Usoft case versus Oracle recently, that some of you may have come across, because that relates to the exhaustion of distribution rights in relation to tangible copies of software. And the European Court of Justice in that case decided that it would also apply to downloads or intangible downloads of software. And as a result of that case, a lot of vendors are looking towards the cloud, because obviously there would be no download involved, but rather a subscription service of sorts, and would render a lot of that case law moot in some way. But coming back to essentially what Ian covered, I think, was very much the same framework that I'd be covering, but obviously I'm not going to repeat very much of what Ian has been saying, but I would concur very strongly with it. And indeed, the papers of Queen Mary, which I've read, I would strongly recommend reading those if you're more interested in this area. From a practical point of view, we see this, as I said, because we've got vendors in this space, several of them in fact, several of probably the main players at a multinational level. We do a lot of their Irish law work, and indeed they license a lot of their products or subscription services under Irish law, even into Europe on occasion. In that regard, I suppose they are looking to be more savvy in relation to how they go about this. So from a regulatory perspective, they want, for instance, to liaise with the Irish Data Protection Commissioner so that they're more au fait with what the expectations there are, and so that when they meet a customer, be a customer in the public sector or financial services, retail, manufacturing, pharmaceutical, that they're able to talk about their service in a manner which appears that they already understand the customer's regulatory issues associated with that service. And that's a key aspect, and the more sophisticated cloud vendors are doing that. Arguably, if you look back 3 or 4 years ago, again, I think one of the reasons that cloud maybe hasn't got up and running, and there are several, maybe that the message wasn't as sophisticated as it is now, and maybe not as market ready as it is now, and indeed the technology maybe not as good as it is now. Picking some other point from Ian's presentation in relation to giving 24 hours before you sign a cloud agreement. Unfortunately, that does happen, and I would say it shows a lack of sophistication sometimes in the customer, not so much in the supplier side, who are essentially going to sell what they need to sell here and get on with their business. But on the customer side, sometimes there's a view, because the document is 3 to 4 pages instead of a traditional outsourcing which might be 100 pages, that it shouldn't go through the normal procurement channels, for instance, within the organisation, and that it shouldn't be a big issue, and we might just, get a lawyer to cast their eye over it 24 hours before it's signed. But unfortunately, that can be quite an involved process to understand what are you buying, why are you buying it, do you know what's involved here, have you tested the service technically, all those questions. So from that perspective, that's really the perspective I'd like to bring on this, in terms of if, for instance, that did happen. Where do we go? I'm not going to labour these first 2 slides, because I got the impression, maybe it's just a feeling, that the audience here has a good familiarity with an understanding of at least the broad concepts of cloud. So I might move into Well, perhaps this slide might be worth talking to very briefly. But there are obviously different types of cloud. Most of you will be familiar with what we call public or community cloud. And there isn't an awful lot of promises, generally speaking, or at least to date, in relation to that type of cloud, although it is changing. But it's a multi-tenanted service, so multiple customers on the same infrastructure. And unless you have promises in relation to where that infrastructure is based, essentially it's commingled data on hardware. And the way to look at it is that it's software algorithms that are separating the data. So apart from normal technical or physical separation of data, you're not able to identify a particular infrastructure anymore that says my data is on an infrastructure or only my data is on that infrastructure, but rather my data is on infrastructure that is controlled by the service provider and it's commingled with other customers' data on that. And it's software algorithms that are basically are controlling the access to and the compartmentalization of that data and indeed the security of that data. So, and that's, I suppose, something to be mindful of. Private cloud, however, then is essentially where the infrastructure is more dedicated to the individual customer. I think it's an important point. That doesn't necessarily mean the infrastructure is on your site. It could be traditional data hosting, where, for instance, the service providers at their location, they have servers within a data center, and you have rack space that's dedicated to you within that data center. And it could be in your home country or it could be abroad, depending on the service that you're interested in. But at least you know, in that regard, that it's dedicated to you. Now, again, I'd like to just address the technology point there just for a moment, because I'm not trying to say that one is better or worse than the other. It comes down again to how good the technology is that manages to separate this data, and obviously it comes down to the service you're buying and where the data is located. Because there's nothing potentially wrong with, let's say, a public sector entity who decided to procure a cloud service but wanted to use it across finance, agriculture and health. And the data, let's say, was held on a cloud servers based outside of the public sector but in Ireland, but the data for all those departments would be on the same infrastructure but commingled essentially using algorithms to extract and process that data, rather than individual servers dedicated to agriculture, dedicated to finance, dedicated to health, etc. So it's just keep that in mind as well, because I think it's an important distinction to be made. But again, it comes down to how good the technology is, because once you get over that hurdle, in many ways, the separation by sophisticated algorithms, there's no particular reason why that's not as good, provided it can be audited and tested, and provided it does the same job. And if there are economies of scale as a result of that, which are obvious in terms of shared infrastructure, then you would like to think that those will be passed on to you, that the service will be cheaper, essentially, than a dedicated service. And hybrid is obviously a combination of private and public cloud. So if a client does come to Matheson with a 3-page contract, or if someone more sophisticated comes to us, I mean, on either side, it really needs to be looked at like any commercial document from the start. It's risk and reward, and the same issues come up: cost, fit for purpose. And I'm not saying fit for purpose there in the context of the Sale of Goods Act, but rather technically and commercially, does it meet your requirements? And obviously, again, just not to labour the point, but testing the service, I would say, is a key practical issue and a practical thing that should always be done. Testing the quality and the criteria and even the SLA on the service before go live. Testing it with maybe a small subset of potentially anonymised data sometimes to not have data protection risk at that stage. But certainly testing the service and then auditing that from time to time during the actual service are key aspects of that. And getting the right people in to test that. Obviously, reference sites is also very important. Like you see in any service provision, you wouldn't buy something without getting decent references, and you might even ask for somebody who has left the service. In terms of data portability, as Ian alluded to, an exit. If you're going to be sure that the promises in relation to being able to exit the service are true, then you might want to ask them to give you the name and number of someone who has left the service and ask them some questions about how easy it was to leave that service. Again, just a practical aspect in terms of, and really testing the service provider in terms of their promises that they're making. So the cost and the basis of charge, I think, need to be clearly set out. It's just a practical issue, but again, you need to understand that, and particularly the scalability of that, because cloud has that I think, fantastic quality, that a lot of it is very, very scalable, and you can add services very easily. However, if you start with an agreement that's, let's say, fit for purpose for a particular scale of job, and manages risk and reward around that, and manages the regulatory legal issues around that, but then you bolt on other services, you need to revisit potentially those terms and conditions. You need to look back at what you've negotiated. Are they now fit for purpose? Are they still going to work for these bolted on services? Because previously I might have had non-personal data in the cloud or less sensitive data. Now I'm looking at other services. And I think I've seen at least a couple of clients make the mistake of actually going a little bit too far and then being stuck with contracts. And I think that might be more prevalent in the future. Again, I'm not saying that vendors are seeking to take advantage of people in this regard. I think not, because I think vendors realise that law and regulation, whether they're subject to it or the customer, they still need to be very savvy around that, and they have lots of reputation around any issues around that, whether or not they were in fact wrong themselves. But obtaining a reliable service that does what is promised, I think that's key. But obviously a contract that underwrites that. I mean, if you have an overzealous vendor who comes in and promises the world, at the end of the day, you need to ensure that the contract, that four corners of that agreement with its appendices or schedules, that gives you what you're buying. Because, it may sound fantastic, and you get your reference sites and you test it, you still need to get those promises in the agreement. As a common law jurisdiction, if it's subject to Irish law, the four corners of the agreement, absent very few things such as fraudulent misrepresentation, which essentially is deceit or lies, most other types of misrepresentation, like negligent or innocent misrepresentation, will generally be excluded as a matter of the contract, particularly if you're dealing with a sophisticated cloud vendor. So if they make a negligent mistake in terms of what they're telling you, or an innocent mistake in terms of what they're telling you, they generally won't be liable, because there'll be a clause in there dealing with that, and the caps and exclusions liability will apply. However, with fraudulent misrepresentation, as I mentioned, they'd still be on the hook, because the caps and exclusions liability wouldn't apply there, but very, very difficult to prove something like fraud. So coming then, confidentiality. Sometimes data protection can get a huge focus in this area, and I think rightly so. But I think I would see data protection as a subset of confidentiality. It's not the same thing, absolutely, but the confidentiality, business data, for instance, at the end, businesses can't afford for their data to be disclosed or used in a manner that wasn't intended by their service providers. It's just a key criteria. And neither can you afford for it to be corrupted, particularly if the backups are also corrupted. And you must be sure that you can access that data, that it's not disclosed, as I said, and there's no unauthorized access, and used only on a need-to-know basis. So confidentiality is a good way of thinking about the same things flow from data protection as they do from confidentiality. In many ways, if you're concerned about the security of the data, a lot of the data protection issues will be caught by those concerns. Certainly in my experience. Now, there are some nuances in that. The integrity of the data, as I said, which is to do with that it's integral, that you can show later that that's the original version. It hasn't been tampered or corrupted in any way, technologically or otherwise. And the availability of that data to use it, to process it, as it's hosted in the cloud. The portability of data and exit, as Ian said, is a vital component. Being able to exit easily without an awful lot of cost is another thing to watch out for in the contracts. What's the cost of exit? Have you negotiated up front, or is it left open to negotiation at the end? So the same issues essentially that you're looking at the start in terms of migration of data to your cloud provider are almost identical on exit, except that you may be bringing the data potentially back in-house, but also more likely you may be migrating to another cloud provider. And then obviously compliance with data protection, including in particular, I think, data exporting rules, because obviously exports outside of the EA are subject to a higher level of scrutiny by the European Directive on Data Protection as transposed in Ireland by our Irish Data Protection Act 88 in 2003. and other applicable laws and regulations. And I mean, there's a host of things, and Ian, I thought, covered exceptionally well the raft of potential regulations in this space. It's enormous, and the reason it is because it comes down to what you're taking from the cloud. It covers such an array of IT services, a lot of them traditional IT services, but there's such an array of what can be provided from the cloud that they each need to be looked at to some extent for their unique requirements, even though they have a lot of commonality also. I'd like to take a show of hands, just very briefly, in terms of, it would have been better to take this before Ian's presentation, which covered everything, but covering it now, I mean, generally, who in the room has got a poor impression of cloud, of what they've heard and read in the last 4 years? Has anyone got a poor impression of cloud? Are we talking to all people? Everyone in the room has got a good impression of cloud. A poor impression?
None whatever. I don't understand what it is.
Okay. So there's only one. And I take it then that everyone else has got, at this stage, a good impression of cloud. Okay. That's interesting, because I did ask that at a presentation about a year ago in Dublin, and I spoke with the Irish Data Protection Commissioner, Billy Hawkes, at an event, and more than half the audience had quite a poor impression of cloud from what they'd read and what their impressions were of it. And some of it, I think, has been, I might cover this, notwithstanding the fact that I think you're all persuaded very, very strongly. And I'm not saying I'm necessarily pro or not pro cloud. It's more about certainly the middle ground. I think it depends is how I'd answer a lot of these things. That data security is a bigger issue in the cloud than traditional outsourcing. A lot of us have got our head around traditional outsourcing, provided you have a decent contract, you have a trusted service provider, you can exit, the data is kept secure, not used for an authorized purpose, etc. Data security is not necessarily, I think, a bigger issue in the cloud. Certainly not now that the technology is much more tested. And so it depends. It depends on what you're buying from the cloud, who you're going to, what the service is, how good the service is, the same issues that come up in outsourcing. Data is hosted all over the world. I think Ian covered this very well. It's not necessarily, it can be. It's good to know where it is, and certainly from a data protection perspective, and I'll come to that, there's plenty guidance that you should be told as the data controller of that data where the data is hosted and what sub-processors are involved in relation to hosting that data. But data is not necessarily hosted over the world. Again, it depends. Another thing that Ian covered, US governments have unique powers to access data in the cloud. Because Ian covered this, the answer is, they're not unique. They're ubiquitous, to be honest. And because of mutual treaties as well, if the CIA and FBI want data that's hosted in Dublin or in Mexico, there isn't a huge issue in getting it in the vast majority of occasions. Provided, again, that there's some controls and rules around that, but provided that justification is there and there's reason suspicion based on it, they can get that data. Cloud is the same as traditional outsourcing of processes. I suppose to some degree there are similarities, but it's definitely not the same. A good example might be something that I read in the Queen Mary literature, in fact, which I thought was a very good example of the difference between outsourcing and cloud. And a lot of my background, in fact, when I worked in the UK, was in outsourcing. And it's interesting now as a migration to cloud, but that if you outsource, for instance, HR and payroll function within an SME, for instance, there's potential that the transfer of undertakings legislation would apply, and let's say you had 5 or 6 people as an SME in that function. They would potentially in their jobs move as well, and those people within the service provider, after go live with the service, would provide that service using that data back to the SME. Cloud is quite different in the sense that those people wouldn't be migrating to the cloud, the data would be migrating to the cloud. Those people would still be processing that data from their desktops, although the data is very much based in the cloud. And there is a difference in a sense that the control of that data, and a lot of my clients will say this on the vendor side, is still very much with the customer. The control, it's more about security, reliability, and the process of that data in the cloud that the concern should be. The control is very much, provided that that technology works and you trust in that service provider, they're not manipulating that data, changing that data in any way. What they are doing is hosting that data and potentially applications as well that are relating to that data on their infrastructure. And you've got a contract underwriting that. But the manipulation of that data is quite distinctly different from an outsourcing transaction, where it's the people on the ground, HR and payroll function, are actually doing that. I think that's an important distinction to bear in mind as well when advising clients in relation to this area. Cloud contracts are not negotiable. I think I'd have to blame some of the vendors for this statement, because they've actually said it to several customers, and I think that's where that comes from. Obviously, it really depends on the deal. If the deal is worthwhile, in my experience, everything is negotiable, and certainly cloud is no different in that respect. And I think as the deal size becomes bigger and the SMEs, larger SMEs, larger corporates, banks and finance houses and the public sector begin to take up cloud, which I think is inevitable, on a more fundamental basis, I think we'll see a lot more negotiation of these deals. Because in the public sector, for instance, with public procurement laws, the public sector entity, if they're sophisticated enough, may be going to market with their terms and conditions to buy the cloud. So that'll be very interesting to see how that develops. They don't necessarily have to put the terms and conditions in play in a public procurement process, but I think if they're sophisticated enough and they're looking at this, they will put their terms and conditions in place and decide whether it's private, public or hybrid. Data protection law does not permit moving personal data to the cloud. Well, certainly I spoke at this event last year with Billy Hawkes, the Data Protection Commissioner, and I was glad because he spoke after me, and I was saying it certainly doesn't prevent, but we hadn't obviously exchanged notes beforehand. And I was delighted when he got up and said, well, I kind of agree with most of what Charles had to say. So that was actually good, because if he had contradicted me, obviously it would have been embarrassing. But I think if you look at the Irish Data Protection Commissioner's website, it's very, very clear that that cloud is being more and more facilitated by the laws, without prejudice, I would say, to the rights and freedoms and benefits of the data subjects. The idea is not to undermine data protection law, but to utilise and think about technology as facilitating this. And so you take away those same concerns. I'll come back to that in a moment, because I think what Ian mentioned about encryption is very, very relevant, and I'll talk to that in a couple of moments when I come on to data protection. Public sector cloud strategies, another thing that Ian mentioned. Very briefly, I just read a couple of days ago that Switzerland have also come up with a cloud strategy, and several other countries at this stage have actually come up with cloud strategies. I would say a lot of them borrowed from each other, to be honest. There's an awful lot of commonality. Very similar headings even in many of them, particularly the one I read from Switzerland a couple of days ago. I'm not alleging anything, by the way, in terms of copyright. But the common features include private or hybrid cloud models with trusted public clouds. So the public sector is looking at this very, very carefully and saying there must be huge economies of scale for us here in terms of how we would maybe procure cloud and what kind of cloud we would procure. So they're looking at, and they're bringing statements out, and I mean, the statements haven't been backed up too much by action, unfortunately, to date. But I think it's coming. It's definitely coming. I think we're led by the likes of the UK, United States, to be honest. And I think other countries will follow suit. A good example is the G Cloud in the United Kingdom. I heard recently, and I have no way of backing this up, it was at a computer law conference in London a few weeks ago that I attended, and it was a partner in another law firm was mentioning to me that when the UK government went to market public procurement for interest in G Cloud services, so services back to the UK public sector, there were something like 260 service providers in the framework that actually got admitted into the framework. There's 260 service providers said, yeah, I'm very interested, I will tender, I will invest in a response to your tender for this. But to date, £1 million sterling has been spent in the procurement of cloud services. So that's 1 million, with 260 service providers have gone to the trouble of actually preparing, I'm sure, very solid responses. And in fact, more, because 260 got onto the framework, so it may have been 300-400 and more that actually tendered for that work. And so what I'm saying, the promise is there, but the take-up has been low. But there's no doubt now with the technology and the interest in this that we're going to see an awful lot more. And I think it will be led by the larger jurisdictions in the first instance. But I think the economies of scale, it really is a no-brainer. I'm not sure if I like that phrase, but it's for the public sector, it's absolutely fantastic for the exchequer, the taxpayer. Joining up government, it seems like the way to do it is to basically allow for a cloud strategy, maybe based on a private or hybrid model. Data to be hosted onshore in home country. Whether or not that's an essential. A lot of these policies are written, particularly the UK one and the US one, 2011. Whether or not it's still essential to have the data hosted on shore is questionable. But again, perhaps, for instance, in the UK, MI5 data, nobody might want that outside of the United Kingdom, and nobody would want that in a public cloud. And that's a good example of the way the G Cloud is structured, because it does categorise when private through public through hybrid cloud might be relevant, and how that data might be categorised in terms of sensitivity. Compliance with law and regulations is obviously a given, and that's mentioned as well in these minimum standards and levels of service. Again, you would have thought that was a given, and that's mentioned. Data control, as in control of the data, so that the control of the data is with the public sector body that puts the data in the cloud, and that they can manipulate that data as they see fit. Data security and data access guarantees. So again, I think a lot of that not surprising really in terms of where things are at the moment. Coming on to data protection. Again, as I said, I often look at this, principally in terms of confidentiality, but then you have to look at what personal data is about. Personal data, I think as the majority, if not all of you would know, is data relating to a living individual. All of us, carry out a lot of transactions online and offline all the time, and there's good reasons that data is intended then to be kept secure. That access is limited to the permissions around that data that you've given, and that the processing and use of that data is also limited, as I mentioned, and that the data shouldn't be disclosed or indeed changed without your permission, and that the data is not corrupted in any way. So in the context of cloud, I mean, those concepts are not quite too dissimilar, except that people are uncomfortable that they don't really know where the data is at any one time. And equally, it may be outside of the EEA, the European Economic Area, which means that the European data protection laws may not apply. And it's those two aspects that make people feel uncomfortable. In addition to, I think, some misconceptions around cloud, just cloud. Because people feel, I'm suddenly now taking an awful lot more risk. The service is cheaper. The contract looks a lot shorter than what I'm used to, and I must be taking a lot more risk. And it's not necessarily always the case. I would say again, it depends, and it's all about the actual service provider and the service that you're buying, and understanding that, and getting a contract that actually underwrites that. The Article 29 Working Party Group. The Article 29 Working Party Group, as most of you will know, is the European data privacy regulators coming together. And basically, they come out then with certain recommendations and advice around data protection. It's a very good idea. In the context of cloud, they produced a recommendation called Recommendation 196. And it was broadly supposed to be more facilitative of the cloud, but what I was disappointed by in relation to that, and Ian alluded to it in terms of it's the encryption technology, didn't seem to get very much of a mention. For a long time, the Article 29 Working Party Group talked about anonymising data. That if you go to a service provider, you anonymise data, then the Data Protection Acts should not apply. I won't get into pseudo-anonymisation, but essentially anonymisation generally means that it's no longer capable, looking at the data or the subsets of the data that have been outsourced in somewhere or put on the cloud, you no longer can identify a living individual from that data or data commingled with that data. And as a result of that, you would have thought that encryption was doing the same thing, because encryption, provided by all accounts, and I'm not a techie, but provided the complexity of the key, the length of the key are sufficiently long, and indeed that the private decryption key, if you like, is kept by the customer or kept securely elsewhere, then essentially that data is not intelligible to anyone but the customer. So if it's disclosed, for instance, in Mexico, and I'm not picking Mexico for any particular reason, but if it is disclosed in Mexico, for instance, then it should be unintelligible, which equally is an issue for the security forces, obviously, because if it's very high encryption indeed, they may find it very hard to decrypt that data if the private key is held by the customer. So it's one of those issues as well in terms of the ability to read that data. I think there were some statistics, I read them 6 months to a year ago, around NASA, around 256 megabit encryption. And it took some supercomputers about 5 or 6 weeks to get to the end of that. And it's essentially guesswork. It's a huge amount of feeding through algorithms of lengths of numbers of codes and actually guessing how to actually get the key. And there isn't anything else more sophisticated than that. Use your supercomputer to guess the key, and ultimately they might eventually come up with the answer. So encryption is a huge a driver here, I think. And once the Article 29 Working Party Group begin to look at encryption more seriously, and indeed I think the European Commission, because there's a new draft data protection regulation out as well, I think they owe it to look at encryption much more seriously. That a lot of these issues will go away, because I think, for one, I think they should be treated very, very similar to anonymized data. Because it's not going to be possible, provided the private key is only held by the customer, to essentially read or, without massive disproportionate effort, read this data. It's in an intelligent way. And I think that shouldn't be forgotten. Now, at the same time, at Matheson, it would take a brave lawyer in any of the firms to say data protection doesn't apply at all to data you put in the cloud, provided the encryption is in place in the private key. And the reason being is that we don't have legislation that deals with encryption. It's all technology neutral, but it could still be technology neutral and deal with this issue. And the Article 29 Working Party Group, and indeed the new data protection regulations, I think if they really want to deal with cloud and deal with more take-up of cloud, they should deal with technology such as anonymization of data, but technology that renders the data unintelligible, and therefore the Data Protection Act shouldn't apply, provided, of course, the complexity and length of the key are long enough, and there's the private key is securely held by the customer. Google have come up with ideas on just making the data very confusing. It's not quite encryption, but again, it's rendering it somehow unintelligible if it was disclosed. So, but I think if they move in that direction, I would see the take-up of cloud being much more extensive, and it takes away a lot of the issues around outside of the EEA as well, because you don't have the Data Protection Act actually applying. And again, I think that's almost a vital component in moving forward to cloud. And I was quite disappointed when I read the Article 29 Working Party Group around that, and surprised to some extent, because I think that's a vital piece in the pie if things are going to move on more rapidly. The Irish, UK, French and Spanish data privacy regulators have individually come out with their cloud policies as well, and most of these talk about carrying out a risk assessment and audits regarding data security. And I might touch upon the audit for a moment. The risk assessment is an obvious one, but it's almost articulated in a way that it's not just about data protection, but business risk, essentially. It's about getting the service you're paying for, the reliability of the data, the use of the data, the non-disclosure, confidentiality, the security of the data. And indeed, if it's an encrypted service, you should be looking at encryption of the data. But the audit point's an interesting one from a data protection perspective, because the Data Protection Acts in Ireland provide that you would need to allow the Data Protection Commissioner and indeed data subjects the right of audit straight through to your cloud provider. Now, you can see that being in a multi-tenanted service in particular, where you've got thousands of customers and you're a service provider, and you have to offer each of your customers, who are the data controllers, direct rights of access as data controllers, and the Data Protection Commissioner rights to audit through to your processors and sub-processors and indeed all your infrastructure. And because the data is often commingled, as I said, and you haven't got identified infrastructure, it becomes an impossibility, to be honest. So for one client last year, in fact, and they were doing this at a European level, we liaised with the Irish Data Protection Commissioner. Other firms were involved in the UK, firms in Germany, in all the European jurisdictions, liaising with the Data Protection Commissioner, each of those. And as a result of that, the Irish Data Protection Commissioner moved quickly enough, and indeed the Article 29 Working Party Group moved after that, where he said on his website that a third-party certified audit would suffice, instead of offering in the contractual terms the right of direct audit through from the Data Protection Commissioner's office, or indeed the data controller, each of them having direct rights of access through to the cloud providers. As a result, an auditor which would certify things to best international standards would come in, for instance, into a cloud provider service and audit that in terms of not all of the data on an audit basis. So they would check the security of the data, the fundamentals of the encryption being used, perhaps this logical separation of the data, as I mentioned, that is actually working, the integrity of the data, to check that these items, this technology that underwrites the service and it says what it does, that's actually happening on the ground, and that the data is secure, is compartmentalized, is capable of extraction, is capable of use, it's integral, and that it's backed up and disaster recovery and business continuity are maintained in relation to that data. So, and that's a very big move forward, because, and I'll come back to it in financial services in my next slide, and the reason it's such a big move forward is because it's causing, it was causing a very big block potentially in the law in relation to that, because it was just not going to be practical and in fact impossible to implement. I started to mention briefly data export, because outside of the EEA, unless the country is deemed to have an appropriate level of security, thank you, then outside the EEA, there are certain rules and that need to be complied with, unless there's a country outside the EEA that essentially has been sanctioned by the European Commission as being a country that also has equivalent protection from a data protection perspective. Israel, for instance, is one. Canada is one. There are some others. Where they have been designated specifically by the Commission as having equivalent data protection laws, and as a result you wouldn't have these special rules applying. But generally outside of the EA there is safe harbour, model clauses and binding corporate rules. Safe harbour is essentially a US system, or principally US system, which is essentially self-regulatory once you actually designate as safe harbour and go through various procedures to make yourself safe harbour. But essentially it means that you sign up to a protocol in the United States as a corporate and say, I will comply with this protocol, which is very, very similar to European data protection laws. So it's binding you in from a corporate contractual perspective as against any type of legislation. However, recently in the Article 29 Working Party Group, which I found a little bit surprising, the sufficiency of safe harbour in the context of cloud was questioned without proof of application. So that they were asking for more in the Article 29 Working Party Group, not just, as a customer, the Article 29 Working Party Group was saying, if you're buying cloud services and your US provider is safe harbour certified, you should be asking for the certification. That maybe is not such a big deal, but you should be asking for proof of application of the protocol that they've signed up to. And you should be asking for that. So, and that's interesting, and presumably that's a frequent requirement that you'd need to be getting. So it springs to mind that maybe that could be covered by audit again in terms of the same issues. But it is interesting that the Article 29 Working Party Group felt it was necessary to mention about the application. I suppose in one sense it follows from the certification. The model clauses, again, I won't go into the various nuances of these, but essentially this would allow you as a matter of contract to export data outside of the EEA. And I suppose one of the issues was that the model clauses are, at the moment, there's the data controller to data processor model clauses data controller to data controller, and also data controller to data processor with sub-data processor. But one of the deficiencies in all of this was that if, for instance, your cloud provider was based in Europe and it was X company in Ireland was providing cloud services to you, there were no model clauses which would allow that provider to have a sub-data processor in the United States. You would essentially need then, in that example, you would need a direct contract as between the data exporter, being the data controller or the customer, and the party in the United States who is the data processor on behalf of your Irish cloud provider. And that was quite difficult because you already had a contract with your cloud provider in Ireland, and now you needed a contract with its sub-data processor in the States because the model clause. Now again, there's some noise around this potentially changing in the very near future. Binding corporate rules are suitable then for companies within a group structure, and they are certainly becoming more frequently used. But again, it's an intragroup structure to basically say that if you've got a group of companies, some of which are based outside of the EEA, you can put in place binding corporate rules, again as a matter of contract intragroup, to ensure that the exporting and exchange and processing of data indeed is all done pursuant to the Data Protection Acts, and those protections and security and safeguards are in place. Another thing in relation to all of these papers is a common feature is that the identity of the sub-data processors should be mentioned to your data controllers, the locations and the security breaches. If there is a security breach, it's basically saying in a contract you should ensure that your cloud provider has to tell you. And I think that's an important point, actually. It's becoming more prevalent as well. And it's the timing around that. It needs to be done fairly immediately once the security breach is substantiated. The new draft data protection regulations, there's quite a bit in there, and in the context of cloud, I think one of the major things would be around encryption, if it's going to come. It's not mentioned at the moment, and it's disappointing, I think, that it's not. Or at least technology neutral around that, rendering data unintelligible if it's disclosed, and provided the keys are actually only held by the customer. I think that's a necessary move forward, and it's something that I'd really like to see personally, and I think the whole cloud vendor space would like to see it. And again, it doesn't undermine the whole principles, and which are really good ones, around personal data and data privacy. In fact, if anything, a great example, again, I would take it from Queen Mary's paper, Ian, you may have come up with this example, that if there's, for instance, a server in Germany, and there's unencrypted data on that server in Germany, but there's very strongly encrypted data in a jurisdiction outside of the EEA, and each are disclosed, where are you more exposed? I mean, in Germany, you've got the protection of the Data Protection Acts, but there's an issue. And in this other jurisdiction outside of the EEA, you've no protection for Data Protection Acts, and there's an issue. But obviously, in Germany, you've actually got an issue to deal with. A much greater issue, in fact, because it's intelligible data, and you're in trouble, essentially. So it's just bearing those in mind that technology is a vital component in all of this, and the adoption of it. I'm very, very nearly finished. Financial services regulation, I'll just mention that there's a raft of stuff around financial services, banks, insurance. MiFID and the Committee of European Banking Supervisors talk about outsourcing, and the view is that this would be categorised as material outsourcing, particularly if they put any financial data in the cloud. Any relevant financial data. HR data may not categorise because it wouldn't necessarily have a critical, important function being outsourced, but any financial data. And it's holding up the whole adoption of cloud and financial services because there's also this audit provision in financial services regulatory advice coming from, like, for instance, the Irish Central Bank, but mainly it emanates from Basel II and III, and then as a result from European directives, where it says that the supervisory authority needs to have direct audit access through to the cloud provider. And of course, that's not really tenable in the vast majority of cases. There may be very isolated private cloud situations where that's possible to give, but in very many occasions it's not, particularly where you're looking for more economies of scale. And it's really holding up the whole adoption by financial services and banks in this space. And it's a very interesting point as well that I think that again needs to move. And again, encryption is part of the answer there. Maybe not the whole one, but just in terms of realising again what the exposures are. But at the moment, this is becoming, I think, a much more acute issue in relation to, for CIOs, for instance, within the likes of UBS, Credit Suisse, Barclays, and I've heard it articulated that essentially the regulation doesn't really allow them to put a lot of the financial data in particular into the cloud at the moment. They need to see changes in that space. Finally then, or penultimately, and I'll run through this very quickly, I mean, limitations and exclusions liability in a cloud contract. I think the normal rules don't necessarily apply. The normal rules in an outsourcing might, for instance, be that if, for instance, you're charged a few €1 million a year for a particular outsourcing, for instance, let's say it was a €2 million deal per year, then the capital liability industry would dictate that it won't be too much more than 100 to 200% in terms of range. Depends on the deal, but 100 to 200% in relation to any claim arising in that particular year, that it won't be much more than 100 to 200%. But in cloud, does that work as well? And I think for smaller deals, it doesn't really work. And the reason is that legal costs are expensive. Taking legal proceedings need to be worthwhile. That if you're buying something and it's only dipping your toe in the water in relation to cloud and spam filtering and various other things, and you're an SME and you're paying 50, 60,000 a year, and the capital outlay is 50, 60, you need to really look at the risks here to say, a 50, 60 grand claim is not going to cover very much here. I might take a necessary risk. So it just needs to be borne in mind. At least you know what you're doing. But I don't think the same understands necessarily apply. I'm not saying either you necessarily have to look for millions, but I do think you need to bear it in mind what you're putting into the cloud, and particularly when you scale up a service, not to be stuck with that same 50, 60k cap. For obvious reasons. You also need to look at the exclusions liability. What if, for instance, any kind of data corruption is excluded liability for? And you will see that, unfortunately, in some cloud deals even now. So you need to be very, very careful around exclusions around data, in particular data loss, etc. It's just to manage that and understand it. If you are going to deal with it, it's the compartmentalisation of that. In what context is that meaningful, and what does it mean in the contract? Service description, including SLAs and KPIs, is a given. Scope and detail of force majeure and downtime. Ian alluded to that. Very, very important to understand when they can drop your service. If you're in retail and it's come up to Christmas and they drop your service for 2 days, you could be out of business. And they might have a right to do that under contract. They might have said it was a big issue for them, like Amazon had, but in reality, I mean, that could happen to you. And if you don't have a contract that says otherwise, you may not have the rights to actually enforce it, to sue them, or to obviously get damages to compensate you in some way for that issue. Subcontracts, including underlying infrastructure providers. A lot of cloud providers are selling services on top of other services, on top of other services, and understanding who's involved in the process, particularly if it's a larger deal, is important. Because otherwise you could be dealing with multiple providers. If one of them becomes insolvent, that could be the end of your data centre, but you never saw them in line of sight in relation to your deal. One of them might even be leasing the hardware. If they stop to make payments on the lease, the hardware, because of retention of title, may well be owned by a leasing company who decides to sell it. And guess whose data is on that? And it's around that issue that you need to be very, very careful. Ability to terminate for persistent material breach, ability to easily migrate data on termination, data backup, disaster recovery, business continuity. So just to finalise, I think the legal and regulatory issues can be managed, but I do think that they need to be carefully looked at from the outset, and in terms of testing, reference sites, as I said. And essentially, like you would look at any other commercial deal, they should go through the normal procurement channels. They should go through the normal, careful assessment of what you're buying, how much you're paying, how long the deal is going to be for, and how you're going to manage it. Cloud insurance, only a few weeks ago I was asked this question, so there's at least a couple of providers, I won't name them because I don't really recommend anyone in particular, but there are at least 2 providers in the Irish market with designated cloud insurance. And it's a growing market in the UK as well, so we'll cover you for accidental loss disclosure of your cloud provider. Despite the fact that they might have insurance as well in play for that, it's nice to know that in case the contract says that or doesn't say that, and they didn't have insurance or something like that, you could have a fallback position just to, again, as you would do maybe in a lot of your other contracts, in managing your risks. Contracts should be carefully viewed commercially and legally. I would certainly say give me hopefully more than 24 hours. And the legal regulatory environment likely to change for the better. Ian covered that very, very well, and I think it is going to change for the better, but certain things are required now rather than in 5 years' time, and I'm hoping things will move on very rapidly. So thank you very much for that.
Thank you very much to John for the informative presentation.
Thank you.
Sorry to put the bomb under you again.
No worries.
Yeah, it's now time for coffee, so you have 10 minutes if you want to stick to the schedule. So it's out the door, turn left, and down the stairs for the coffee. Thank you.